I said I had read through the new U.S. Citizenship Act of 2021 really quickly. I read through it in like an hour. I had more time to digest it over the weekend. A lot of it on my first read I got right, but I did leave out some things because I read it very fast. So I just want to go through it again. Now, I don't want to spend another 45, 50 minutes talking about it simply because whatever we're talking about now may or may not end up being the law. So as we learn more and things become more definitive, we'll definitely be saying this is going to be in the law, this is going to be out of the law. But right now, this is what is being presented to Congress by Joe Biden, Kamala Harris. They are Democratic president, Democratic vice president, to a Democratic Congress. All three parts of our government, the executive branch, the legislative branch of both Congress, Senate, and House of Representatives, all controlled by Democrats. So this is why people are very excited, because these immigration laws are always being discussed. But this is the first time in my history of being an attorney that the Democrats have controlled both houses of Congress and the executive branch, which is the presidency, which is why people are getting extra excited that maybe this will be the year that we finally get immigration reform. So let's go through it one more time. Again, if you want to know more and more about everything, go back and watch our show because we talked about it for about 45 minutes. But I do want to go through it quickly. In the new U.S. Citizenship Act of 2021, they are going to be increasing employment-based green cards. Right now, they give 140,000 green cards out a year to all employment-based cases, and that's the EB1, EB2, EB3, the EW category, the EB4, the EB5, and if you want to know what that is, EB1 is extraordinary ability and intracompany transferees, EB2 is advanced degree professionals, as well as people working in the national interest. EB3 are your skilled workers, EW are your unskilled workers, EB4 are your religious workers, and EB5 are your million-dollar investors. Now, out of that 140,000 green cards, it is not one green card per application or one green card per family. It is one green card per human being. So if you get sponsored in a job and you're bringing your spouse and 3 kids, now you're a family of 5. That's 5 people off the 140,000 for employment-based green cards. So that's why there is such a huge backlog on immigration cases. What they are doing now is it is one green card per family, one person off the list. So the accompanying family members are not going to be included in that 170,000 green cards instead of 140,000. So it's going to be a real 170,000 job sponsorships per year. Because right now it's probably 30 or 40,000 job sponsorships per year that get through on green cards simply because you're counting each accompanying family member. They are also going to be removing the per country limits. That affects the Philippines, that affects Mexico, that affects China, obviously affects India. There have been some people who hypothesize that some Indian IT professionals may be waiting 100 years for green cards because of the per country limits. That is all going to be removed. They are adding the 30,000 green cards, not across the board, but they are adding it to the EB3 category. They are adding 30,000 green cards to the EB3 category. They are increasing the EB3 category from 40,000 to 70,000. Those are your skilled workers, your bachelor degreed workers. They're also adding 30,000 green cards to the unskilled workers, raising the limit from 10,000 per year to 40,000 per year. Those are nannies, housekeepers, caregivers, people who work in factories. Usually the job sponsorships from the factories are from the meat and dairy factories. Also, they're going to recapture lost green cards between 1992 and 2020. It's estimated that they're going to recapture 225,000 lost green cards that will be added to the quota. So now all of a sudden they have increased the quota, they have reduced the per country limits, They are not including children and spouses as part of the quota. They're adding 225,000 new green cards, as well as saying if you happen to be waiting more than 10 years for a green card through an employment-based case, you're going to get your green card right away. There's no more waiting. That is their increase in employment-based cases, or should, in theory, eliminate the entire or most of the backlogs that people are facing right now on employment-based cases. They are also going to enshrine into law, it's right now an executive order, but they are going to enshrine it into law that people on H-4 visas, H-4 are spouses and children under 21 of H-1B workers, your professional specialized workers, they're going to enshrine it into law that the spouses can get work permission. If you remember, Donald Trump tried to eliminate that and tried to remove that executive order. He was sued. The case was in the courts. It became eventually moot now that Donald Trump is no longer president. It will now be enshrined into law. Also, H-4 children are no longer going to age out. Why is that important? So if you start a job sponsorship, you file a perm application, you file an I-140 visa petition, your child is 16, 17, 18 years old, and now all of a sudden you find yourself waiting 4, 5, 6, 7, 8, 9, 10 years or longer for a green card through a job sponsorship. Well, you may be okay because maybe you can renew your H-1B or you're on some other visa status, but your kid turns 21, he's off the case. Now the kid's age gets frozen at the time you file your perm or your I-140, whichever comes in first. That way your children will never age out. As for students, this is a big deal for students, and it's a big deal for colleges and universities. Probably one of the most important things that they could actually do for students other than give somebody a green card. They're going to eliminate the non-immigrant intent required to get a student visa, and now a student visa, you can have a dual intent. Why is that important? It starts with you going to apply for a visa at a U.S. embassy abroad. When you are a prospective student applying for a visa at a U.S. embassy abroad, you have to be able to prove that at the end of your studies, you're going to return back to your home country. Now, all of a sudden, that eliminates many, many prospective students who want to come and study in the United States of America from getting their student visa because they're not able to prove that when their studies are over, they're going to leave. Maybe it's because of their family situation. Maybe it's because of from the area that they come from or the demographic that they come from would indicate statistically, because the U.S. government works on statistics, that these are certain people who don't leave America. Well, now you won't need to do that anymore. Now to get a student visa, if this law passes and they eliminate that non-immigrant intent, for all intents and purposes, as long as you can show you're not a threat to commit crimes or terrorism or anything like that, and you can show that you can be able to pay your tuition without taking a job, you will get the student visa. You just need a good sponsor now. That's it. You don't have to show that dual intent. And then what also is that once you are here as a student, maybe you get sponsored in a job. You can get sponsored in a job and you can be at school at the same time. And you want to know what? Maybe you want to travel back to the United States and travel home and come back and you want to get married the following week. Now you don't got to wait those 90 days anymore. It is going to be a huge change for students to be able to get out of that non-immigrant intent issue and have student visas be dual intent. And that, by the way, is going to flood U.S. universities with foreign students. Now, also what's going to happen is that if you are studying in science, technology, engineering, and math, you are no longer going to need to leave or be subject to number quotas on who can get sponsored in a job. If you are a science, technology, engineering, math degreed major, you would be eligible for a green card immediately, provided you have a job offer. Now, for those who are not science, technology, engineering, math, and have the OPT, they can do a job sponsorship directly for a green card and keep renewing their work permit year after year until they get their job sponsorship complete. So now if you get your OPT, optional practical training, at the end of your student visa, and it's good for 1 year, right now you have to get into the H-1B category. You have to find an employer willing to sponsor you for an H-1B, hopefully get into that quota on the H-1B, and if not, have to go home or re-enroll in school again. Now you can forget H-1Bs if you choose to and your employer chooses to. You can go straight for a job sponsorship, start a perm, start an I-140, and while that case is pending, be able to renew your work permit year after year until you get your green card. The same is going to be for L1 visas as well. They are going to be extending the number of people who get diversity visa lotteries from 55,000 to 80,000 visas. Now, we talked about on Thursday lawful prospective immigrant status. That is the status that people who would be eligible for the amnesty would be putting themselves in that status. Lawful prospective immigrant status will be given to people who are here in the United States undocumented as of January 1st, 2021. It will also give lawful prospective immigrant status to anybody who is a dreamer. A dreamer is somebody who entered the United States under the age of 18, no matter when they came, and it has a high school diploma or a GED and is 2 years in college and 2 years in the military, or they even have a waiver if you can't do the 2 years in college or 2 years in the military or the GED, but you can prove you came here under the age of 18, and for compelling reasons, you can get a green card anyway. Maybe you have some sort of disability that you couldn't finish high school or college. Those people would be screwed. Not anymore, because you can file for a waiver of having to finish high school or college. And we talked about for the last couple weeks that in order to be part of the DREAM Act, you had to be here for 4 years and you had to be under 17. Well, that 4 years is not there. I read it 3 times. I never saw that you had to be here for 4 years. I just read had to be under 18. So if that sticks and I'm reading it properly, I hope I am, then basically, as long as you are under 18 when you entered America, and this all happened before the law passed, and Biden signs it, and you can show that you are in the process of getting your high school diploma, your GED, 2 years in the military, you would get lawful prospective immigrant status, and then ultimately be able to adjust once you complete those requirements. Now, it would only, for the dreamers, and as well as for the people who are just here out of status on January 1st, 2021, as well as we're going to talk about the TPS and the farm workers as well. For all 4 categories of amnesty applicants, you just need 1 applicant in the family to qualify, and everybody does. So if you're in a married situation, if one of the spouses qualifies for any one of these amnesties, and the other spouse does not, and the children do not, well, guess what? Now they do. So you only need 1 family member to qualify everybody. Now, for people who are in the DACA program and have been approved as DACA applicants, they're going to get a streamlined adjustment. They will not have to go through the lawful prospective immigrant status and then adjust. They will just go straight for adjustment. Now, this lawful prospective immigrant status, it's good for 5 years. And then between year 5 and 6, you have a 12-month period to adjust your status, and then you fall back out of status undocumented. So you got to make sure if this law passes, and this is the way it ends up, that you got to remember in 5 years you got to do something or forever hold your peace. For TPS members, you don't even have to be a member. You don't have to be in the TPS class to be able to adjust your status on a streamlined basis. You just have to be, your last country of residence before you made it to America was a TPS country, a temporary protected status country. And you were here in the United States when the bill passes, you will be eligible for adjustment of status. So, Yo-Yo and Vanessa, many of Donald Trump's shithole countries will now get the last laugh if this, in fact, passes. You know, because all the TPS countries will be, all you have to do is basically it's going to be an amnesty for people from these particular countries. You had to be here when the bill passes, and you had to show physical residence on January 1st, 2017. Now, if you are part of the TPS program, or you are from a TPS country, but you couldn't show you were here on January 1st, 2017, maybe you came here under the age of 18 and you're in high school, and you can show you would be under the DREAM Act. Or maybe you were just here undocumented at that point on January 1st, 2021. There's going to be multiple amnesty applications that you may be eligible to file for. So if you don't fall into one, you could fall into another. But, we'll have to see how it all pans out. There's going to be the agricultural worker amnesty, and that is if you were here for 5 years and you worked on a farm for 400 days or 2,300 hours, again, you would be eligible for streamlined adjustment of status. Now, we talked about it on Thursday also. 1 felony or 3 misdemeanors, you're out. But you're not necessarily out, because you could always file a waiver based on family unity and humanitarian reasons. So even with multiple crimes, you may, depending on your situation, be able to show rehabilitation and be able to show that you would be eligible nevertheless. Now, for refugees and asylees, will refugees and asylees be eligible for any of these amnesties? And the answer is yes, you will be. So if you are in asylee status or pending asylee status and you haven't gotten your green card yet, you will be eligible. If you are in removal or have been ordered removed, you can file these applications and have a stay of removal while it is pending. So even people who have been removed and have not physically left the United States will be eligible for this. There's going to
Brad,
be...
Wet Sugar asks, are they going to be able to travel to their country?
The answer is yes. When you have... Will asylees be eligible? It depends on the situation. There is still fraud. You still have to show that you qualify for an adjustment of status, good moral character, not have committed fraud against the U.S. government. So it depends.
How about the banned countries?
The banned countries you will be able to go to for sure. Those countries are no longer a problem. Under the law, as it's written right now, you will be able to get travel permission and work permission for up to 180 days to leave and come back, but you can't stay out for more than 180 days.
I have on YouTube
Yes.
marry, taxing, nothing for overstayed people. So is there anything for anyone that's here overstayed?
Yes, the answer is yes. You would fall under the general amnesty, which is if you were here as an overstay on January 1st, 2021, you would be eligible for your lawful prospective immigrant status. So anybody who is here undocumented, out of status, overstay on January 1st, 2021 would be eligible. If not, you could always file for adjustment. They are going to be eliminating the 3 and 10-year bars. You can do an adjustment. You can do a job sponsorship, and the number of job sponsorships are going to be doubling and tripling. So presumably you would be able to do a job sponsorship, go home and come back without a problem.
Tori Davis asked, Brad, do you really think Biden will end the family ban before the 31st of March?
No, I think as of April 1st, and we've been speaking to U.S. embassies around the globe just for our current clients, and the general information we've been getting back is they'll be called sometime after April 1st, which is which is the day after. So even I believe the U.S. embassies don't believe anything is going to be revoked before then, but I would be very surprised, especially now that they're opening up here in New York City, for example, theaters, indoor dining. It seems that COVID is going down in the United States. I would be very surprised if Joe Biden, who seems to be a very pro-immigration president, would invoke the ban beyond March 31st.
And what about VAWA applicants?
VAWA applicants, there's no changes to VAWA applicants. VAWA applicants will still be able to adjust their status just like before. Now, one thing that's going to change, though, is the inclusion of permanent partners. Permanent partners are going to be put in the same position as a spouse. So a permanent partner is defined here in the law is a committed, lifelong, intimate relationship, and you have a financial relationship. So as a permanent partner who would be put in the same position as a spouse, not only for sponsoring for a green card, which you can right now in a same-sex marriage, but a lot of times you can't do a same-sex marriage in countries where maybe one or both partners live. Or perhaps you're a permanent partner and your other partner is coming on a work visa. You can't come to the United States as an accompanying spouse because you're not qualified as a spouse. Now you will. The other thing what they're doing is, which I thought was very interesting, I didn't see this the first time, I read it the second time, I had to actually read it twice. They're now basing parentage on not only having a genetic parent biological relationship, but now also they're basing parentage on having a relationship with a child in their first year of birth. What would that mean? In other words, for example, I thought of two ways that this would be relevant to people. One is people who do IVF, and maybe perhaps they're not using their own genetic material. They wouldn't be considered biological parent. They couldn't sponsor somebody, sponsor a child. Or somebody, especially in same-sex relationships, where one is a biological parent and the other one isn't. And now the non-biological parent's the American. How do you get that child into America if the child's born in another country? Or I've had situations which were very, very sad in my practice, where families took a child literally from a hospital because either the mother passed, unfortunately, or the mother abandoned it. Literally, I've seen situations where mothers walked out of a hospital and left babies behind. I had a client several years ago, and she was a nurse, and she just took this baby and raised this baby since the baby was born, but never adopted the baby. And then as the baby grew and grew, wasn't their child. It was an adult already. We couldn't do anything, even though this baby was with this mother since birth. So, I mean, I could think of a lot of ways where that would come into play. For naturalization, there's two things that they're doing for naturalization now to make it easy to become U.S. citizens once you have a green card. One is if you're over 65 and you've had a green card for more than 5 years, you don't have to take the written test of English. So over 65, green card for 5 years, you can speak any language you want. Also, if you graduated high school here in the United States, you would not be required to take the naturalization exam, period. Also, they're going to roll back the 5-year wait for citizenship if you can prove that 3 years before you obtained your green card, you were lawfully employed in the United States. Meaning, then it would be a 3-year wait after you got your green card, not 5. So, for example, there's situations where people have H's, L's, E visas. They've been working here for years and years and years, finally got their green card, and then have to wait another 5 years. Well, as long as they were able to show they were employed for 3 years before they got their green card, their wait would only be 3 years for citizenship, not 5. Or the other thought I had was people sometimes adjustment applications are pending for years and years and years, and they keep renewing their work permit year after year after year. Well, now that time period would be counted towards citizenship, and you'd be able to do it for 3 years instead of 5 years. And they're also going to enshrine into law that people who file for asylum must get their work permits within 180 days of filing. And finally, if you're filing for asylum, you do not have a 1-year bar to apply. You can apply whenever you want, whenever you realize that you have a fear of returning to your home country. Now, I summarized a lot more. There's a lot more I talked about Thursday. I don't want to be repetitive, though.
Nikisha Bailey saying, what about people that have entered illegally? Will they qualify to adjust their status through family sponsorship?
No, they will not. They would still have to go home, but you wouldn't have a 3- and 10-year bar. If you came illegally before January 1st, 2021, and you're going to be physically here on January 1st, 2021, well, it's very possible that you would be eligible for lawful prospective immigrant status. Maybe you say, you know what, I'm scared to go home. I don't want to go home and get my green card and come back. You can do the amnesty. Perhaps you entered without inspection through, and your last residence was a TPS country. You can apply directly for your adjustment. So most people who come in, I wouldn't be surprised if have multiple options on.
I have one on YouTube quick. I have Kiki asking for the DREAM Act. If the DREAM Act is passed, would those kids get immediate green cards?
If the DREAM Act is passed, the people in DACA would get immediate green cards. People who are not in DACA, if you were under 18 when you came to the United States, you graduated high school or a GED and do 2 years of college or 2 years in the military, you would be eligible for adjustment of status. But the DACA recipients would be immediately eligible, which is a different category.
Cynthia Francis asked, what if you come on a B1, B2 visa and didn't go home? Are those people included?
Yes. Those are visa overstays, undocumented visa overstays.
Right. From Elizabeth Francis, what about if you have a son who's over 21 and you're a green card holder? How long will it take, or will there be a new law to get them here faster?
Yes, there will be a new law. We talked about it Thursday. That was the V visa. I just brushed on it. I said about one sentence about it today.
Awesome.
There's going to be a V visa that for anybody who has an approved I-130 visa petition for their children, whether married, single, whether you're a resident, whether you're a citizen, they would be eligible for V visas to come to the United States, to reside in the United States with you. They would get work permission while they are waiting for their green card. So they would be able to wait in America with you instead of waiting in another country once the I-130 visa petition is approved. The other thing is the F2A category, we talked about that on Thursday as well, is going to be immediate relatives. The F2A category, those are spouses of permanent residents, those are children under the age of 21 of permanent residents. Those are going to be considered immediate relatives. Immediate relatives means there's no quota. You can get your green card right away. Thanks for watching. For more Brad Show Live, like and subscribe to our YouTube channel.